Hello, and welcome to another U.S. Tech Workers podcast. I'm your host, Kevin Lynn, and I'm joined again by Rolf, who has been in Oakland sitting through the proceedings of the Buchanan versus Tata Consultancy discrimination trial. Rolf, welcome to the podcast again.
Hi, Kevin. Thank you. Good to be back.
Well, it's great to have you here, Rolf. So, Rolf, tell me, from what you heard today, you were able to see today, what jumped out at you? What were like the big things that happened today?
There was a really compelling testimony by a U.S. tech worker who was with TCS for 18 months. And we also heard a couple of HR representatives from Tata. And some of the information that came out of that was, I think, really significant.
Right. And these were all witnesses produced by the plaintiff's attorneys, correct?
The first two were a result of the plaintiff's attorneys. And, in fact, the first thing we saw today was a deposition videotaped. And it was a continuation from yesterday, but it was the end of the cross-examination by the defense. And so that was really significant too.
Oh, okay. Well, great. Do you want to just then jump into highlights from each of the testimonies that you saw today?
Absolutely. The first thing was that an HR rep who had a 5-state area, and she had begun her video deposition yesterday, or that was shown yesterday. And they wrapped up today with the cross-examination. She verified again that the culture of Tata is Indian, that she was circulating the Pulse survey, that's the employee feedback forms, for reassignment, for non-visa related placements. The efforts given by RMG, and that's the Indian recruitment arm that's external, they were ineffective for local hires. And so if Tata were hiring Americans, they would be local hires. They would not be expats.
And that's essentially what they seem to be doing, correct? And it's funny because all we hear today when, these politicians are giving these tax breaks to these outsourcing firms to locate to their cities, and they're really not hiring Americans, they're hiring expats.
Absolutely, and there are a number of methodologies for doing that, and that's more or less what the trial has been about.
Did they go into any of those methodologies? Well, I know we talked about some of those yesterday. Did anything come out of the trial today? Well,
to finish up with the video deposition, she absolutely reaffirmed that there's anti-American sentiment. And then when she was talking to the lawyers for the defense, she said within the HR group. But she was really, really definite about that when she was talking about the attorneys for the plaintiffs. So I think there are some differences there, but this was very decisive, I think.
Interesting. Did you say anything specific that that really jumped out at you?
The thing about the non-visa related efforts to place people, they were ineffective for local hires. I thought that was just amazing.
Interesting. Now, describe that in a little more detail. Yeah, please, for the audience, please, expound upon that, what that all means.
Somebody will be hired by Tata because they were already in a position, and Tata came along and got the outsourcing contract. And then typically
so let's say you're working for company ABC, and ABC says, we're going to outsource your position, and the next day you come to work, you're working for Tata, correct?
Exactly.
And then what would be your fate after that?
Sometimes I think they lasted over 2 years, but, within a relatively short period of time, especially in comparison to the way some of them had spent 15 years to over 30 years on these jobs, they would be benched.
Wow.
Without any reason given. And then eventually they would just be terminated, because once the candidates are put on the bench, they typically have about 1 month to get placed. And supposedly that's up to them. And there's a lot more coming out of this testimony today that helps to clarify, why the trial is taking place in the first place. But
and these people that did occupy these positions, they're working for Tata, they get benched, and they don't get placed. That's the problem, correct?
Correct.
Interesting. Now, was there any testimony given that, so they might be benched, they might have been in that position for 20 years, they've been working for Tata, let's say a year, and they're benched. Did someone from Tata then fill that position?
In almost every case, they were required to train their replacements, people who were possibly in India at the beginning of the process, and people who may have come to the United States initially on an H-1B visa. And then after that, it's kind of up in the air exactly what they're going to do, where they're going to be placed, or where they're going to be working. But essentially, they are replaced by H-1B visa holders.
I am dumbfounded by this. Oh my gosh. It's like the fix is in to terminate them from the day they start working for them.
Exactly. Yes.
Wow. Was there any testimony as to the wage differentials between, let's say, someone who had that position prior to it being outsourced to Tata and then the Tata replacement?
I don't recall anything like that from the testimony, but I can tell you that one of the U.S. tech workers who provided testimony previously, and I believe that was yesterday, he was on salary when Tata got the outsourcing contract, so that apparently continued at the same rate.
Okay.
He applied for a job that he was completely qualified for. It was posted as $80 an hour. And after he won the job and he was awarded the job, he accepted the offer. Then he received a phone call. And the essence of that phone call was that he would be compensated at the rate of $40 an hour instead of the $80 that was posted. And he had already been accepted. He had been logged into their system as assigned. So they wanted him on that job. He was ready to pack up and leave. And then suddenly he found out apparently they were retaining him at the same salary. That's my guess. But the job was posted at $80 an hour.
And I wonder what they were billing the client.
There's no information that way, but those are the figures that have come out so far. I mean, in terms of salaries, the people were kept at exactly the same salary level, but their benefits were cut.
Wow. This is how it happens. It's this wage suppression, and there's all these forces at work that lead to that. And this is how workers get kicked out of the middle class. It's tragic, absolutely tragic. Wow. So what other interesting highlights came from the testimony today that you'd like to share, Rolf?
There was another development with the last American tech worker to be interviewed or to be examined. He had worked for some agencies in the past. I mean, he had 20 years of experience as a developer. Then he was placed by Tata in 2 contracts over a period of 18 months.
Okay.
After he was let go, then he was also not eligible for rehire by Tata when he saw their postings. Any company that was placing contractors through a different agency, like a subcontractor for Tata, he was no longer eligible for those, even though he had already worked for those agencies in the past.
Wow. So if, let's just say, he had been on a job with ABC company and then 123 company, and he gets laid off by Tata, he could never work for ABC or 123 company.
Yes, even though he had been employed by those agencies in the past. he was blocked.
Wow. Oh, so even if he were employed with them, let's say before his time with Tata, he still would be eligible for hire with them.
Correct. He couldn't go back to agencies that had employed him in the past.
I'll be darned. Wow. That's
another wrinkle that we haven't even touched on yet.
right, which is the, what is the term? It's when you, it's not indentured servitude, but the reality is you're simply blocked. It's blocking you from practicing your trade, essentially.
Exactly.
Wow. 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 So what else came out of today's proceedings?
There were documents that were verified by a current Tata HR employee, and she was the workforce manager. She said the head of workforce management. She also described her title as resource management, talent management, and what she does is she starts and approves recs.
Okay.
And so really the core of this testimony was verifying documents that are internal to Tata, and especially an HR directive that was to use every visa to the maximum extent possible.
Mm-hmm.
L1B 5 years, H1B 6 years, L1A 7 years.
And making
so
sure they're maximizing those times of the expats then.
Correct.
Well, and so she was essentially, the defense was using her because she works for Tata to validate and verify the documents that they had entered into the trial.
It was Cochin and Lowe, the attorneys for the plaintiffs.
Okay, gotcha.
Yeah.
Yeah,
they wanted to have someone from HR telling everyone that those documents were authentic.
Yep. Yeah, I can see that. And I think that's important for the jury to see. It's that little bit more validation. So what else came out of the trial that jumped out at you, Rolf?
There was a description of mapping Tata employees to existing openings within the company. And so there was basically a snapshot that we looked at, or that everyone looked at. 1,063 unallocated visa holders were in India. And the primary job of the HR department, from what it sounded like, was trying to map those individuals first to jobs in the USA.
Gosh, and that just, it demonstrates the lack of objectivity. Because I worked with Robert Half Technology for a year, so we were basically placing people. And for us, it was all about looking at the skill sets and mapping those skill sets to the job requirements. And then I would go to the company that had put out that rec, and I'd say, hey, we got someone that fits this, this, and this, and this. But that doesn't seem to have been the case. The primary writer was not the skill set, rather it was, are you from India? Is that an accurate interpretation of that?
In fact, a lot of the recs could even have the stipulation that they were only looking for a visa holder. The requester, the person who was entering the rec, could stipulate visa holder.
Wow. I mean, that's definitely, absolutely country of origin discrimination. Now, you had spoken with one of the attorneys trying to get some clarification on the kind of effort when it came to burden of proof that would be required for the jury to find for the plaintiffs. And you sent me that email, and I think it might be really helpful to our audience for me to read that to you.
Yes, please do.
Yeah, because you would ask them, is it up to the, you were kind of asking, like, is it up to the employer to prove innocence following allegations of EEO violations, discrimination? And the attorney had responded to you, and that's Daniel Cochin. He said, hi, Rolf. These are pretty involved questions. We'll have jury instructions coming out that will speak to the burdens here. But generally, the applicable burden a plaintiff must meet is referred to as a preponderance of evidence. Burden meaning a more likely than not standard. Because this is a pattern or practice case, it involves a burden shifting framework. If a jury finds that the plaintiffs have proven a pattern or practice of discrimination, the jury instructions should have a good description of this burden shifting framework. I hope this helps, Dan. So very interesting. I think that's quite helpful. And one of the things that I would like to do for our audience is later this week, have Donna Conroy, Bright Futures Jobs, come on and kind of describe what EEOC is, because we seem to have lost track of what equal employment opportunity is, where it came from, and how it needs to be implemented to be effective. But thanks for that, Rolf. That's very interesting.
Yeah, I don't know whether I mentioned it before, but the directive that we covered earlier in HR wasn't known to anyone apparently who has testified previously in this trial. So I mean, that was a very high level document, and the people who were carrying out these policies on a day-to-day basis didn't know that document existed apparently, and they didn't know of that policy officially, but it does exist, and that was verified. So a couple of the numbers, if you want to look at those.
Sure.
Okay, one of the attorneys for the plaintiffs wanted to know whether recs for 2,000 locals in one shot had ever been seen by this HR individual.
I'm sorry, say that again. There was a little bit of noise. Can you say that again, Rolf?
Sure. 2,000 locals in one shot. That was the question. Because he had emails requesting 2,000 expats at the same time. The answer was no. Another email requested 2,500 expats at one time, mapping that many expats to jobs in the USA. And again, the answer was no. She didn't want to answer that question, but he got a no out of her. So they're not placing local candidates the way they are expats.
Wow. So obvious bias right there. Obvious country of origin bias right there.
And there was some even better information a little bit later on.
Pray tell.
It was stats for layoffs and terminations from the bench in USA. And these are based on racial characteristics. And the time frame here is April 14th, 2011 to December 31st, 2016. So it's a really long time frame.
Yeah.
That should be typical, I think. There's 78% non-South Asian that were terminated from the bench. 22% South Asian.
Wow.
And you can compare that if you want to non-bench outside the U.S., non-bench in the U.S., and the figures were that non-bench in the U.S., 75% non-South Asian, 25% South Asian.
Interesting.
Outside the U.S., 34% South Asian, 66% South Asian. So it looks like, maybe there's a little bit more of a level playing field outside the U.S., non-bench outside the U.S. South Asians were being laid off at an extremely high rate, terminated at an extremely high rate in comparison to non-South Asians.
Wow. And, add that to what they'd said about the levels of competence of the South Asian employees that the U.S. counterparts were forced to train. Wow, very interesting. So, Rolf, did anything else jump out at you?
Absolutely. There was something that was so incriminating, I'd say, against the defense that it was hard to believe, because the last U.S. tech worker who provided testimony was on his second assignment for Tata, and everything was going beautifully. He was getting compliments, and he was training people at 2 previous accounts. Then suddenly, there was a meeting. He was in the meeting, and his supervisor said, budget cuts are coming up. And he told some guy who was from South Asia, he told an Indian guy, only locals will be released. Expats need not worry. And
he said this in a meeting. He said in a
meeting, yeah. And he apparently wasn't very mindful of the fact that there was a U.S. tech worker there. And he was the one who was laid off. He was the most senior level developer. He has a master's, in fact, 20 years of experience. They laid him off, and they retained the people that he was training.
What did they tell him when they laid him off?
That was the guy where they didn't tell him anything, not a single word. The phone started ringing with unidentified caller ID.
Okay.
He ignored it at first because he didn't know who it was. Finally, he picked it up, and it was HR calling him to tell him that he was laid off, and they wouldn't answer any questions. They just hung up. He said the sound of that person's voice, apparently somebody that he had known to some extent from the past, was robotic. Like, she was just mechanically reading through a script, and hung up the phone and wouldn't call him back and wouldn't answer calls. Nobody would communicate with him after that. And he was blocked from several other agencies that were his previous employers before he got to Tata.
That's inhumane. That is just absolutely inhumane treatment. My blood is boiling hearing that. Wow.
I don't think it's out of the question to say that they're trying to take aim at American professionals and their careers.
Absolutely. And I have, since 2 years ago is when I really got involved with the plight of U.S. tech workers. And I have known so many who simply become so despondent because opportunities, that they'll go to interviews and yet nothing comes to fruition. They don't get the job offer. And it's now at the point where it's almost rote. They almost know what they're going to be asked ahead of time, and they know they're not going to get the position. It's almost like the people they're applying with are just going through the motions of being able to say, oh, we are trying to hire other than the people we want to hire in all of this. And, and what it does is ultimately it hurts America because, one, it obviously hurts these people who are not getting the jobs, but it also hurts those who might have ambitions to become tech workers. Invest money in a college education for a computer science degree, knowing that this is the kind of world you're going to go out into and try to market that degree in. It's just not right.
I think Americans are getting the message, just forget all about any technical career because you'll be discriminated against and you'll get pushed out of your chosen profession. Wow.
Well, Rolf, it's up to us at this point. If we have to get our congressional leaders to act on this, even though many are paid to do different. We see that with the campaign contributions coming from corporate lobbying groups, the presence of, for instance, on December 9th, the House Appropriations Bill for Department of Homeland Security goes to the floor for the vote. And on July 25th, in the evening, in a non-recorded vote, a poison pill was slipped in it for U.S. tech workers. And there is a bill, H.R. 392, which basically eliminates country caps that Congress and congressmen and senators have been trying to get passed that would end essentially country caps that are, when it comes to green cards and employment visas, for the sole purpose that the system will then go to pretty much allow them to only bring in Indians from South Asia, because that's who's in the system waiting to get queued up. Releasing these country caps will allow that to happen, and that has to be stopped. That appropriations bill comes to the House floor for a vote on December 9th, if you're listening to this podcast, you absolutely have to call your congressman and tell him no on HR 392 and to have that amendment stripped from the appropriations bill. Call your senator too, because that appropriations bill will then go to the Senate. The Senate right now doesn't have that amendment in it, but they could follow a path of least resistance in a lame duck Congress. And if you want to learn more about that, we have several blogs on that on the ustechworkers.com site. So, sorry, I went off on a tangent there, Rolf.
It's okay with me. There was just one other thing that came out of the testimony that I saw, and we haven't touched on it yet, but I don't know if you would have another minute or two to
Sure,
talk about
absolutely.
the recs that people put together.
Yeah.
If somebody doesn't want to fill a rec, I think that this is really ancient history. I'm sure everyone has run into it, but one of the witnesses for the plaintiffs came across a situation where he was put on the defensive, more or less, because there was a combination of skills in a rec that didn't even really make any sense. They wanted somebody with, let's say, Java development experience. I can't remember exactly which language it was. They also wanted project management, and then there was some third really key skill. And the way these skills are combined, maybe somebody has all of those skills and all of that experience in their background, but what are the chances that that person is going to come in with really current and really strong development skills if they've been out of it for a few years? It'll probably take them a little while to get back up to speed, and then whoever the employer is would be able to challenge that because they put together a rec that's extremely difficult to fill.
Interesting. It's designed to, it's a poison pill rec. It's designed
Yes.
to not hire. It's designed to actually weed people out and not find someone for a position.
I've got to tell you, I ran into something when I first started in technology. I had about a year of experience, and I went to a more serious technical company. It was a networking company from a different country. And one of the people who was highly involved with this company from the beginning, like she started with them when they had possibly 10 employees, and she was doing everything that needed to be picked up, picking up the slack everywhere. And she told me that what they had for open recs for the United States were 2 visa-based recs. They would have to have visas because those skills didn't exist in the United States. Their development group was overseas at that time, and they wanted somebody who had development background in their proprietary software. So they were just trying to get more visas, and she admitted that to me openly. The recs had been open for 2 years, obviously, because nobody in the United States would have those skills.
Interesting. Wow.
But recs like that will get thrown into account of open positions in the United States, you see.
Wow.
So when those figures come up and they're presented to Congress or they're published or anyone gets figures like that at all, I think you can see what they're doing. It's not rocket science.
Yeah, exactly. And they get to say, wow, there are jobs we just can't find Americans to fill. They don't mention that they're looking for unicorns in all this. Wow. Well, Rolf, anything else that you want to share with the audience?
Oh, not right now. I don't really want to get started.
Okay.
I think we've done enough for one podcast.
Yeah, that we have. We've certainly gone over our 15 minutes. Well, it's actually a bittersweet night for us because this was another fantastic recap with you, Rolf, but this will be your last one for this foreseeable future because this trial is going to drag on every day between now and December 6th, except holidays. And you have to work, unfortunately, for us and our audience. So that's tragic. I don't know if we'll get someone else to pick up the slack there. But it's actually a good place to break because this was the last day that the defense was going to be calling their plaintiffs. It'll now be Tata calling their witness, or excuse me, the defense calling their witnesses, and it will now be Tata's opportunity to call their witnesses. And Dave and his team, or Dan and his team, will be cross-examining Tata's witnesses, the way Tata's attorneys cross-examine the plaintiffs and the witnesses of our plaintiffs. So, Rolf, I want to thank you for the 3 days that you gave us. This, I know I've gotten so many emails, and again, listeners, thanks for those emails, and thank you, several people, for your donations. Those really help us keep our operations going here at U.S. Tech Workers. It's a big deal for us to get those. It shows us, one, that we have an audience out there. This is important to people. And validates what we're doing. So thank you for those. Thank you for hitting the thumbs up on the YouTube page and subscribing to our YouTube channel. And that's about it. Rolf, again, thanks for all your time.
Absolutely. It's been a pleasure.
And good night. And we'll be in touch soon with more great podcasts coming to you from U.S. Tech Workers.